We're going to get started. We're at noon now. And as I mentioned a moment ago, I'm Paul Price. I'm with the People's Law School, and we've got Sarah Forte and Jim Wu with us to talk about returning to work during a pandemic. We've got a 45-minute webinar for you, and we're going to start by welcoming everybody. We've got a quick poll to run you through. We would just like to have a sense of who we have with us today. The options are a worker, someone who helps people with legal problems, a legal professional, and none of the above, but interested in the topic. So we'll just let that poll run for a few moments. And in case you're wondering, there will be a recording of this webinar that will be distributed in the days that follow. So if you aren't able to attend all of it, that will be available to you. And we've got our poll results, and it looks like we mainly have workers with us today, 61%, and we've also have some people who help people with legal problems and some legal professionals. So thank you so much, everybody, for joining us today. It's really wonderful to have you here. So in today's webinar, this webinar is intended for workers in British Columbia who have questions about returning to work during the pandemic, and the workers are primarily those who are covered by employment standards. What you can expect today is we will be doing a Q&A, answers to the most common questions that we received at the People's Law School and also that Sarah and Jim have been receiving at Forte Law. We'll be providing legal information as opposed to legal advice. So if what you're looking for is information that applies to your specific set of facts, what you may need is legal advice. And if that is the case, we would offer info at Forte Law. You may contact Sarah or Jim there. And we offer information that is current as of today. So it's May 20th. As you know, the landscape is rapidly changing and the laws are in some cases as well. In terms of questions, if you have questions that you would like to have answered, we will be having a window at the end to answer some of them. So please put those in the Q&A as opposed to the chat. If you see a question that you like, then hit the little thumbs up button, and that will promote the question in terms of popularity. It'll increase the chances of it being answered. We also have a comment section. So if you have questions about tech or you just want to make a general comment, that's where you can place those comments. And we're getting very close to introducing our speakers. Just one last, make some acknowledgements before we do that. And the first is that we would like to begin by acknowledging that the People's Team is gathered on the unceded territory of the Coast Salish peoples, and that's made up of the Musqueam, Squamish, and the Tsleil-Waututh Nations. And we recognize that we have participants joining us from across the province, and so we just wanted to extend that acknowledgement. We'd also like to thank the Law Foundation, whose funding makes these programs possible. And on behalf of Peoples, we would just like to thank everybody for participating today and to have the opportunity to be here. And I'd also like to extend a thank you to members of our team who are behind the scenes making this operation run smoothly. And again, just really want to highlight how delighted we are with everybody being here today. I just saw we have 215 attendees on the line, so super happy about that. And of course, there are our guests of honor without whom this would not be possible. And so Sarah Forte, the founder of Forte Law, and Sarah has been an employment lawyer for I think it's 16 years. And she was with us at the beginning of the pandemic. She did a wonderful presentation about our rights as workers in the pandemic. And Sarah reached out to me a few weeks ago suggesting that we do a follow-on webinar now that workers are being called back to work. So wonderful idea. Thank you, Sarah. It's so great to have you here.
Thanks, Paula. We're so excited to be here. Jim and I were talking about, we get lots of requests to run webinars for businesses, and we have done a number of those, but our firm acts for workers and businesses, and so we thought it was really important to have an information resource for workers. So thanks to you and to People's Law School for giving us this platform to share information.
Well, thank you so much for being here, Sarah. It's wonderful to have you here. And Jim, Thank you for joining us. So great to have you as well. So Jim is also an employment lawyer with Forte Law. He's a former adjudicator with employment insurance, and Jim has a passion for translating legalese into language that that I can understand. So thank you. Thank you, Jim. Thank you for being here.
My pleasure. It's always great to speak to the People's Law School and to get all the make complicated information easier to understand and accessible to everyone.
It's so wonderful, and Jim has been helping us with some of our some of the materials on our website as well. So thank you so much. And we are going to turn to the frequently asked questions now. And Jim, I believe this first question is for you. And this is a question that I've seen in multiple different shapes and forms. The key piece being, what if I don't feel safe returning to work?
Right, so that's a very important question that's going to come around for every workers. What you need to know is your employer, they do have a legal responsibility to make sure that the workplace is safe for you to work and safe for you to return to. That being said, though, your employer doesn't have the obligation to make sure that you're 100% protected from any exposure from COVID-19. So it's a bit of a fine line to basically decide, is my workplace actually safe versus is it really just my own personal sort of gut feeling that's making me not want to actually return to work. One objective way to see whether your employer is actually taking the right measures to implement new safety protocols is WorkSafe BC, which is our regulator for health and safety concerns. They've made it an legal requirement for every employer to have what's called a COVID-19 safety plan. There's 6 steps required of this plan, and I always like to use acronyms to kind of break down very complicated steps. So I have here, it's called WINDOW. So you have the WINDOW, and I'm just going to go over each of these letters very quickly. So the W part, that's basically the workplace risk assessment. And this involves your employer getting their whole team together and identifying what are the hazards of work? What are some of the places that people gather together where there's a lot of risk for workers getting exposed to possible exposure to COVID-19, and basically finding ways to minimize those contacts and implement measures to reduce exposure. So that goes to the second part, which is the I, implementing protocols. This is actually the brunt of what's expected. And again, I like to emphasize this is a team effort. It involves you and it involves your employer working together to basically come up with a plan to minimize exposure and to maximize workplace health and safety. Now going to the next letter, N. So that's basically involving you and your employer nailing down new policies to make sure that health and safety are maximized. So it involves deciding who will be coming back to work, what are some new measures that are to be taking place to help ensure the best safety measures for all of the workers in place. D, so that means developing communication plans and training. So that can include having signages in the workplace to remind workers to, here are the steps you need to take to maximize your health and safety, and to also ensure that others comply with it. It also includes signages in the event that your employer deals a lot with, say, members of the public, to remind the public, here's what you can do to make sure that my workers are being protected while they go out and serve your needs. We're almost there. So the O represents having an open door policy to allow you to make recommendations to your employer regarding any health and safety concerns. So this is not an option. This is actually a legal requirement for your employer to give you the right to voice your concerns about what's going on in the workplace. And your employer has the obligation to work with you to try and tackle this concern. They don't have to absolutely satisfy it to your end, but they do have to take it seriously and work together to actually address this concern with you. And finally, the last W is making sure that your employer actually walks you through the changes whether that means retraining you, doing reorientation, since some businesses have been closed for quite some time. Basically, it's an open dialogue that your employer has to always have with you, and it's a team effort, and we're all in this together to make sure that we get businesses back and employees back into their jobs, and that the economy goes back the way it was before. Sarah, do you want to add anything to that?
Well, I had not heard the window acronym before, Jim. That's brilliant. I love it. I guess the one thing I would add to that is employers have to, Jim referenced the COVID safety plan, and employers have to post that at work. And you can also ask to see that. So if you're being asked to return to work and you would like to know what precautions have been taken for your safety, you can ask the employer to provide you with their COVID safety plan. And that will help you know what precautions have been taken. And there's lots of information on the WorkSafe website about that. I know Paula's going to send out some links after, but that's a really good resource if you want to sort of check what they've given you against what the requirements are.
Okay. Well, thank you, Jim and Sarah. And yes, I believe we're dropping a link to that in the chat box to the WorkSafe site. Clearly, people have been thinking about this and how to create safe work sites for workers. And so really helpful to know. And thank you, Jim, for the window acronym. I love acronyms myself. It's always helps to remember.
That's Paula, that's by far the #1 question we're getting right now is about people concerned about safety. So totally appropriate. We nailed that one down first.
Yeah, absolutely. And thank you. And I gather another question that is really high up on the list is, sorry, I'll switch the slide over, is what if my job has changed? So in some cases, it might be something quite large, like your title or your duties. It may be the number of hours that you are expected to be, that you're required or expected at work. What then?
Right, so there is a concept in employment law, it's called constructive dismissal. The elements are, as with any sort of legal terminology, there's components of this remedy, and the components are, there must be, #1, a unilateral change that is material, that's the second aspect, material to a term of your employment. So what does that mean? Unilateral means it's got to be changed without your input or consent, and the material aspect means it's got to be very super important to your job and your employment. So what are some examples of material changes? Reduction to your salary, changes to your how much you make. And we're talking about a fundamental change. So if it's a reduction of, say, 5%, that may seem to you to be quite a fundamental change. However, the law looks at it through objective lens, meaning they apply what's called what would a reasonable person in this employee's shoes think? Would that be considered to be a very fundamental reduction? That's the question that they're looking for. So our courts, there is rules from our court saying if the reduction is 20% or more, that would be considered a fundamental change. At which point, then you're looking at the next question, which is how long are these changes going to be instituted for? If it's something for just a very short concrete duration, such as for the next pay period, that might not reach the level of it being a material change. However, if you ask your employer and the answer is, well, it's a temporary measure we're taking place, we don't really know yet when we're actually going to institute, whether we're going to actually restore it or whether it's going to be a permanent change, then that you might have a much stronger position to say that you've changed, without my input, a very critical component of my job. You basically fired me from that job and replaced it with a job that's pays me a lot less than what I was making before. I've been constructively dismissed. When you assert that allegation, however, you have to be very important, because when you assert constructive dismissal, what happens very shortly afterwards is you leave your job. And that at this moment can actually, it's a question you have to take a lot of thinking, because there is a lot you can risk by resigning from your job. you have to prove that there was constructive dismissal. And if you are unable to prove that there was, number one, a unilateral change, and number two, that the change was material to your term of employment, then it would just be seen as a resignation, in which case you won't get any compensation for your decision to quit. Sort of tie into that, I always try to find creative ways to tie in EI to any advice I give on employment law matters. The same applies for EI. They apply sort of a just cause test where they look to see whether you exhausted all reasonable alternatives besides just quitting your job. And the question that every single employment insurance adjudicator would always ask a claimant is, well, why couldn't you have paid you less than what you were making before? But why wouldn't have to give them a very compelling reason as to why you chose to quit your job the way it was, and basically depend on the Canadian taxpayers' monies to fund your decision to make yourself unemployed. Anything you want to add to that, Sarah?
No, that was really thorough. I think that was well handled. We get a dismissal is the legal concept that applies. But it's definitely a risky road to go down, I think, is the bottom line there. If you're going to pull the plug because what you're being offered looks different than what you did before, you really want to look at
you're not entitled to CERB. So if you do get it right now, the government can ask that it be returned on that basis.
Yeah. Thank you, Jim, and thank you, Sarah. I think what this highlights is that these are some pretty thorny, change of job, or the material pieces of it. This idea of safety, these are topics that are quite delicate and can be really difficult to have a conversation with your employer about. But Sarah, you and I have spoken before that a large part of what you do is help workers to approach discussions that they need to have with their employers. So do you have any advice or suggestions or ideas for how one might approach a difficult conversation with an employer?
Absolutely, Paula. That's thank you for that question. These are many of these issues around return are going to be challenging and stressful. And I think one thing to keep in mind is these are often challenging and stressful for your boss as well. They're challenging and stressful for lawyers. The world is changing and everybody's feeling a bit insecure with things. So, though that creates a bit of the perfect storm to have some conflict if people aren't approaching it really carefully. So I haven't developed an acronym for this, but now that I've heard about Jim's acronyms, I think I'll talk to him about that. And maybe he'll have one by the end of this show. But I always think of it in terms of some steps. So whenever I am talking to an employee or frankly an employer who's going into a difficult conversation, the first thing I say is identify your goal. So really think before the call or email or whatever you're going to send about what it is you're hoping to achieve. And so if what you're hoping to achieve is having some additional safety precautions taken, or maybe you're hoping to just not go back to work. Maybe you just don't want to go back to work quite yet, but you want to leave the job open. Understand and really think about what your goals are. I find sometimes people launch into these discussions without having a clear understanding on their own end necessarily of what they want, and they're sort of reacting from a place of fear or emotion, and that rarely leads to productive results. So number one is, it sounds simple, but it isn't always. Think about what it is that you would like and what you're hoping to achieve. So what's the point of having this conversation in the first place, okay? And then number two is think about who's on the other side of the conversation. So, if Paula's my boss and I am, perhaps I have I make it a little simpler that I don't have kids at home that are in school, though I do, and so does Paula. I have maybe an elderly parent that's living with me who has some chronic illnesses, who is in a vulnerable category. And so I don't feel ready to come back to work yet. And so what I am hoping for is Paula's asked me to come back to work, but I would like to have a remote work arrangement continuing. And so if I'm going to approach that discussion, the first thing I need to do is identify my goal, as I've done. Okay, I want to keep working remotely for sort of an indefinite period. And then I need to think about Paula, and so step into her shoes the best I can and think, what is Paula thinking right now? What is she going through? What's on her mind? What are her goals? What does she want? And really take the time to think about that. And you're in a really good position as an employee. Hopefully you have some kind of relationship with the person you're reporting to, so you would know a bit about them and know a bit about what the company is trying to achieve. That is very helpful, because whenever you're trying to persuade someone or convince them to do what you want to do, if you can find some common ground between what they want and what you want, it can be really, that's where the magic happens, right? Because then it's not a conflict, it's not a difficult conversation, it's a win-win. So I'm always looking at those kind of mutual benefits and really thinking about what is in the other side's interest. So perhaps there's some, a project I can offer to take on that Paula needs done that I can do remotely. And I know maybe it's kind of like that project nobody else wants to do. And I know that, so I can take something off her plate. You think about things that you can offer to do that will help sell this remote work arrangement. And the next thing is consider the manner of how you're going to communicate. So I've thought about my goals. I've thought about Paula and what she's looking for right now. And now I'm going to, and I've discovered what I think are some common ground areas. So now I'm going to think about how to communicate that to Paula. And I often get this question of who should I ask? And I say, well, it's just like with parents. You ask the one that's going to say yes, right? So think about who to approach. There are no rules about that unless there's specific rules in your workplace, like a hierarchy. Maybe I could talk to Paula, or I could talk to HR. Maybe Paula supervises me jointly with someone else, and maybe that other person is Jim, and I know Jim's a lot more flexible, or Jim's a lot more tech savvy, so he's going to be comfortable with it, and Paula's kind of rigid. So I might think about who to ask strategically. Now, you don't want to go shopping, right? Just like that doesn't work at home with kids. It doesn't work at work either. So if Paula says, no, I'm not going to turn around and ask Jim, I need to pick my horse and ride it, right? So I'm going to figure out who to ask, and then I'm going to think about how to ask. Like, emails can be very good. Because you can control the content of them. You could have maybe someone else look at it before you send it. You don't have to worry about where the conversation is going. But emails can also be really impersonal, and it can be hard to get a tone. So if you, like I, have great relationships with Paula and Jim, I would be way better off calling them if I was going to try to convince them to do something. And then I can also listen, right? In a phone call, meetings in person aren't happening right now, maybe Zoom. I can listen, I can watch their faces. I'm trying to judge how what I'm suggesting and talking about is going over. So listening is the last important piece, is really understanding and making sure you're not approaching it in a confrontational, one-sided way, like this is what I need, and this workplace is unsafe, and this has been horrible, and you're a bad boss. But where if it's like, hey, Paula, I love working with you. I'm so excited to be part of the rebuild. I'm in this situation right now where I've got this, my grandma living with me, and she's really vulnerable, and I'm just really afraid of her getting sick. And so I would love to find some ways that I can keep contributing from home. I have some ideas, that I've come up with, but I'm also really interested in hearing if you might have some ideas. So I've delivered Paula the problem and the solution at the same time, but also let her be in control by adding what she wants.
Yeah.
So I don't know if anyone has anything to add to that. That was really detailed, and I didn't let either of you speak, even though I used you in my example.
No, it's I love the, I mean, I think it's all extremely useful suggestions on how to approach any difficult conversation, frankly, and specifically one in your workplace. The example that you chose is, I think, one that a lot of people are asking about right now, is having that flexibility to work from home. So that was a neat way to approach it. And I appreciate that, Sarah, so much. We have, and I think there's a link going into the chat, resources on our website about how to approach difficult conversations. And I think just this act of sitting down and preparing and thinking about the perspective that you're bringing, and like you said, bringing a solution, you're being proactive. Here's what is, here's what is good about this arrangement, is a wonderful way to approach it. So, so thank you for that. I'm going to move on to our next question. Which is, as employees and workers are being called back into the workplace, one question that has come up is, what are workers' rights in relation to who is being called back when?
Right. So I think that, there's so many different aspects to this, but the one I'd like to focus on, because it's something I'm seeing and hearing and frankly worrying about, is discrimination under the Human Rights Code. So when employers are looking at who to call back, my working theory is it's kind of like a game of musical chairs, where if they're adding people a few at a time, at the end, there's not going to be enough seats for everyone at every organization. So some people are going to be left out of the economic recovery party, so to speak. So that is, and who are those people going to be? My concern is that's going to be working parents, that's going to be pregnant women, that's going to be people with disabilities or older workers, because as the employer is going through the list and thinking about who they're going to call back, in a completely well-intentioned and caring way, I think often those groups of people are going to get bypassed, because I'm going to think, well, I know Paula's got her kids at home, she's super busy, I'm not going to bug her, I'll move on and I'll call Jim. But in effect, what's happened then is I've bypassed Paula without giving her the right to say, oh no, actually, I can come back to work and I have childcare, and I want to come back to work. So employers in some cases might be making that decision for workers, which is the problem. So we are, just because I've planted the issue of working parents, I am going to come back to that in more detail, but I'm just addressing this piece more generally. So if you fall into one of those categories, and there's a list of protected grounds under the Human Rights Code, which I'm sure is probably on people's law schools resources, but the primary ones that I think are going to be engaged are age, sex, which includes pregnancy, and disability, and family status. Those are protected grounds, which means that employers aren't allowed to treat you negatively because of those reasons. So what I would say is, if you feel that you've been passed over, like let's say you're about to start a maternity leave in a few months and they call everyone back but you, that would be a really obvious example, then you may have a claim for discrimination. And what I'm suggesting is people deal with that proactively. And if they feel there's someone that might get bypassed and they would like to return to work, that they put themselves on their employer's radar and just raise that as a proactive solution.
That's great. Thank you so much, Sarah. Again, I always appreciate that you offer sort of ideas and really emphasize the proactive, the ability to be proactive as an employee. We talked about school-aged kids, and this is something I think is hitting home for a lot of parents. what happens to the protected leaves and that sort of thing that we talked about back in April?
Yeah, so this is, one of those areas that's ever changing. And of course, as a working parent myself and an employment lawyer, I'm watching the changes very carefully. You know, the the government put in a protected leave under employment standards. That happened very early into the pandemic. It was one of the first changes that was announced, and it covered a bunch of categories, including parents who have to care for their minor children due to school closures or daycare closures. So those are still protected. It's an indefinite leave. There's no end date on it yet. I know for me, we're in the Surrey School District, so I'm watching all the announcements come out, and what I'm seeing so far is voluntary return that is quite part-time for school-aged kids. And so my expectation is that leave will continue to be engaged and will continue to cover working parents until school is open sort of fully. That will be a decision the government will make, because that leave was intended to be temporary and won't be part of the act going forward once we're all through this pandemic. So we'll hear when it ends, but for now it's still going. So if your employer calls you and says, you know what, we need you to come back to work, if you have minor children at home you need to care for, then you're entitled to say no, and you can't be fired because of that. But you also don't need to be paid, so it's an unpaid leave.
Excellent. Thank you so much, Sarah. And we've got one last question on our list before we turn to the live Q&A. So Jim, I'm going to lob this one in your direction, and it is this. What if you decide that you do not want to go, or that you're not going back to work, or you're invited back and you refuse? Oh, you're on mute.
Sorry about that.
That's okay. No,
it happens once in every webinar. It's like, there we go.
So the main question you need to ask yourself is, why are you deciding not to go back to work? And again, this can range. The answer depends on what you answer to that question. So I'll give you a few examples. So if the reason why you're not going back to work, let's use the example of health and safety, since that's sort of in the back of everyone's minds. If the reason why you're, let's say you get a call from your employer asking you, I have work available for you, and then you ask your employer a few questions. Okay, I'm a little uncomfortable right now returning to work because of the COVID-19 situation. I do understand that we're required to have these new measures sort of being implemented in our work site. Can you give me a bit of a status update to that? And your employer answers, oh, well, I didn't know that. I don't think that's really a requirement. I think like what we had before will be more than adequate to address any sort of potential outbreaks of COVID-19. And you believe that whatever measures were in place were just simply not at all in compliance with what was recommended by WorkSafe, then in that case, there would be probably a valid reason for you to probably postpone your decision to return to work. You can frame, and the justification will be because you feel that there's some objective reason for you to not return to work because of some pretty legitimate health and safety concerns. But if, on the other hand, your employer tells you, I've implemented everything that's required, he shows you his window plan, and all the items on there have been pretty much implemented, and he even says, look, I even took some of the considerations through some of the discussions I had with you in mind, and we've implemented everything. The whole staff is ready to go back to work. I'm just asking you whether you want to return to work or not. And at that very moment, you decide, no, I still think there's something probably that's lacking, and you decide not to return to work, then that will probably be considered you quitting your job, and which case there are some possible ramifications you need to deal with, specifically in relation to your continuing entitlements to social benefits. So for example, as I mentioned earlier, CURB It's paid to you if you lose your job by reason of COVID-19. However, like the Act says very clearly, if you decide to voluntarily quit your job, which actually the example I just gave does actually fall into the category of you voluntarily quitting your job, then in that case, you would be losing your entitlement to CERB payments. Furthermore, with EI, two things can potentially happen. One is if you haven't applied for EI, they might consider that to be a quit, in which case, very likely you're going to be asked the same set of questions by the adjudicator. In the latter scenario, I'm pretty certain to say that it's not going to, the applicant would not get EI just because they had the option to return to work, all the safety measures in place. And the question you're going to have is, well, why didn't you at least show up for at least one shift of work and give it a test run to see how things go? So your EI can be, if you haven't applied for EI, you will likely not get EI. If you are on EI, your EI might also get discontinued because you have essentially refused work. And you also quit your job, which will basically put an end to any benefits that you might be payable down the road. Anything you want to add to that, Sarah?
Yeah, I'm just going to add one thing, which is, usually employees have quite a bit of rights to privacy in terms of sharing information with their employers. So it's a bit of a weird situation. But what I'm suggesting to employees is if they have a reason why they're not returning, that they should disclose that. So if the impression that's left with the employer is, I'm just, busy here planting my garden at home and I'm not really interested in coming back to work, that's not a good reason. And that could be grounds for you to essentially have quit your job. But if you have school-aged kids or, some other reason, you're experiencing symptoms, those are things you should be upfront about, and not wait till the employer even asks why, because if you don't provide that information, they won't be able to take that into account.
That's a good point, Sarah. And the example which Sarah also gave as well relating to the protected leave provisions, if you provide information telling the employer that I had to care for a family member that's affected for COVID-19, and I simply am not in the position to return to work, that can also be seen as a valid grounds for refusing to return to work as well.
Yeah, and I think that.
Yeah. Oh, go ahead, Paula.
I was just going to say thank you that appreciate that if you simply decide to go back and you don't have a reason that is recognized, like a leave situation, or you're caring for a family member, or you're sick, there are certain circumstances where you'll be treated differently. But if you just simply say, as Sarah said, you're planting your garden and you don't want to go back, that you're basically forfeiting your rights to the benefits that we were just talking about, the CERB and employment insurance.
But you'll have a lovely garden.
You'll have a beautiful garden, and who doesn't want that? No. But anyway, so I'm going to go. We're going to turn to some live Q&A. We're getting very close to the end of our broadcast, but and so we're just going to switch into a different view, and bear with me as I open up the questions. I'm going to pick the one at the top because it has 17 thumbs up. And it says, how do you handle a situation of person at work with symptoms who say they have allergies? Is it okay for people to attend work with allergies active? Okay, and this seems to be coming up quite a bit.
I can answer that. So that relates to the nailing down your policies part. So there is a legal requirement now. I'm just going to read it. So it says, the Provincial Health Officer and the BC Centre for Disease Control have issued the following guidance around self-isolation, which must be reflected in a workplace policy. And these are as follows. Anyone who's had symptoms of COVID-19 in the last 10 days must self-isolate at home. And these symptoms include fevers, chills, new or worsening cough, shortness of breath, sore throat, and new muscle aches or headache. Anyone under the direction of the health officer to self-isolate must follow these instructions. And anyone who has arrived from outside of Canada or who is in contact with someone who is confirmed to have COVID-19 must also self-isolate as well. So going back to the question there, if it's the case where the employee has demonstrated that they are probably symptomatic, the employer does have the right to ask that employee to self-isolate. Actually, the employer has an obligation to make sure that the employee is self-isolating, and the employee also has an obligation to make sure that they are taking steps to self-isolate as well.
This is going to be something, Paula, that is going to just like, we're going to have to all figure this out as we go. It is part of what's going to happen here, because this is completely untested territory. We've got these guidelines, we've got a few laws, but we're going to have to see. I can tell you, I had a friend who had a child in daycare at the beginning of this who had a chronic cough, and what the daycare required was a doctor's note that said what the cough was not COVID, essentially. I understand COVID tests are turning around very quickly now. So if you're someone who is an allergy sufferer and you have chronic symptoms that are similar to COVID, that might be something you can address with your doctor to get some kind of proof that can let the employer say, okay, this person is safe to be at work. It's a great question. It'll be really interesting to see how that unfolds.
Yeah, and thank you both. Those are excellent responses. I'm going to turn to the next question. I think we're going to try maybe one or two more. We're getting very close to our window, and we know people have need to move on. So, but I imagine we're going to see this one too. Is it a responsibility for employers to provide masks to protect employees? I think it's meant to say.
Right. So I can maybe give a bit of a overview. So in terms of implementing protocols, it will depend on sort of what the nature of the employee's job is. They over at WorkSafe, they've instituted 4 levels of protections. Having masks available is sort of at the far end, which is the level 4 protection, and it's generally reserved for those employees who are unable to physically distance themselves. So for example, hygienists working at dentist's office, basically people who have to come into close proximity . Then it may just be the case that the employer might just offer that employee the opportunity to continue working at home, in which case masks are not required to be actually provided to that employee.
Great answer, Jim. One of the things about the WorkSafe information, when you go to the website, they've issued guidelines by industry now, which is really helpful. So, the one that I read yesterday was on offices, because I'm making our own plan for our office. And so what it says, like Jim says, there's 4 levels of protection. So number 1 is physical distancing. Frankly, I can't remember what 2 and 3 are, but PPE, which is personal protective equipment, is number 4. And the idea being you would provide that if you aren't able to meet the other safety criteria.
Excellent. Thank you. It's so useful. I'm going to skip the next question because I see there's resources that have been provided. And I'm just going to turn, this will be our last question, then we'll kind of wrap up. If someone's mental health is not allowing them to feel safe and secure to return to work, and they get called back to work, can that person take sick leave? Some people's anxiety is so high that the fear of returning is having a negative impact on their health. What are the legalities around this?
Yeah, that's a great question. And I think a lot of people are worried about COVID and about returning to work. There's some people who have been really, hardly left their houses in the last few months. So I think it is a real worry. If you have a mental illness, like a diagnosed mental illness, for instance, like a general anxiety disorder or some other mental illness, that means as a result of that condition, you are unable to work, that then becomes a human rights consideration. And whether you can take sick leave depends on whether you have a disability and whether that disability means you can't return to work. If I was going into a discussion with my employer about that, I would go in armed with a sick note, because I think that it's very hard when you look at the employer, standing in the employer's shoes, you know, everyone has some amount of worry about returning to work and COVID right now. And so being able to understand who is, you know, I think Jim had a really good way of putting it, like just sort of not feeling safe versus who is got a clinical level of anxiety around returning to work that means they're incapable of returning. That's not something your employer can figure out. They're not, nor would you want them to. So if you can go in with some solid information, that will really help. And I would suggest, you know, unless you have a very good relationship with your employer and maybe they're aware that you have some mental illness issues, maybe you can resolve that with a discussion. But I think in most cases, you're going to need to produce a medical note that would say that you're incapable of returning to work, be due to a medical illness. You don't necessarily have to say what it is, but you have to have a doctor that would say that that means you can't return to work.
That's a good point, Sarah. And I would add, just sort of for the EI perspective, also be prepared to arm yourself with a medical note saying exactly what Sarah put down, sort of something along the lines of unable to return to work due to medical reasons. There are provisions within the EI Act that allows for claims to be processed where the claimant's unable to resume work because of reasons relating to their health and safety, including any sort of existing illness that they may have.
Yeah, thank you both. I think that's so helpful, and I imagine there's a lot of individuals in that situation where it really is, you know, the anxiety is preventing them from functioning in their employment. So unfortunately, we're out of time. We are at 12:45, and I would love for us to be able to go through all the questions, but we won't be able to do that today. Please stay on the line, everyone. We're just going to say thank you to Sarah and to Jim for taking the time. This has been so helpful, and we really appreciate you sharing this information with us.